Welcome, and thank you for tuning in to today's episode of the Consumer Finance Monitor podcast. I'm Alan Kaplinsky, the founder and the former chair for 25 years, and now Senior Counsel of the Consumer Financial Services Group at the Ballard Spahr law firm. Today's episode is part one of a two-part series featuring a repurposed webinar we presented on May 12th of this year entitled Coerced Debt, New York's Law and Emerging Trends Nationwide. In the first part of this discussion, our speakers explore the background of coerced debt. They break down the framework of the New York statute and examine how the law impacts creditors and debt collectors. Part two of the series will be released next Thursday, June 18th. So today, we're going to be exploring an issue that's gaining significant attention among policymakers, consumer advocates, regulators, and the financial services industry alike. Namely, the topic is coerced debt. And in particular, we're going to be focused today, although not right at the beginning of the webinar, on New York's groundbreaking new statute addressing the issue. At a high level, coerced debt refers to situations in which an individual is forced, manipulated, or deceived into incurring debt without meaningful consent, often in the context of domestic violence, intimate partner abuse, or other forms of financial exploitation. Historically, the legal system has struggled to provide clear and effective remedies for victims of this type of abuse. New York has now enacted what I'm referring to as a landmark law, first of its kind in the country, creating a framework for consumers to assert that debts incurred through coercion should not be enforceable. The statute raises important legal, operational, evidentiary, and policy questions, not only for consumers and advocates, but also for creditors, servicers of debt, debt collectors, debt buyers, and compliance professionals. New York enacted its coerced debt statute in 1925-1926, and amendments were signed into law in March of this year, delaying the effective date until June 17th of this year. The amendments purportedly narrowed aspects of the original law and refined creditor obligations. Similar laws, or I should say similar bills, they're not yet laws, are pending in Vermont and New Jersey. So today, we have an outstanding panel that's with us to discuss these issues from a variety of perspectives. First, we're joined by Professor Angela Litwin. Angela is the Charles Sapp Chair in Banking, Financial, Commercial, and Corporate Law at the University of Texas School of Law. She's nationally recognized for her scholarship in bankruptcy, consumer law, and commercial law. Her current research focuses on the relationship between consumer credit and domestic violence, the topic that we're going to be very focused on today. She also is studying attitudes toward bankruptcy among consumers sued by debt collectors and bankruptcy legal culture. She has many published works, including this general subject of coerced debt. I'm not going to list all of them. There are too many to list. But she's been involved in funded research on this topic. And I think it may be fair to say that the term coerced debt was coined by Angela. And just in a couple of minutes, I'll be turning the program over to Angela. Next, we're joined by Divya Subramanian and Naomi Young from Kamba Legal Services in Brooklyn. While that's where they are located, I know that their legal services organization services all of New York City, all of the boroughs, not just Brooklyn. Divya is a supervising attorney with the Consumer Law Project at Campbell Legal Services. It's a community-based nonprofit that provides free legal services to low-income New Yorkers, including debt defense and affirmative litigation in state and federal courts, with a special focus on victims of crime. Divya co-authored the 2018 report entitled Denied: How Economic Abuse Perpetuates Homelessness for Domestic Violence Survivors. And she's been a key member of the coalition for advocating for New York's coerced debt legislation. And she is joined today by her colleague, Naomi Young, who is a senior staff attorney in the Consumer Law Project at Campbell Legal Services. Naomi co-chairs the Domestic Violence and Consumer Law Working Group and is a founding member of the Economic Justice for Survivors Collective, which successfully advocated for the enactment of New York's coerced debt law. We're also joined by Carla Sanchez Adams. Carla is a senior attorney at the National Consumer Law Center, focusing on emerging issues in banking and payment systems, fintech, and the economic right of survivors of domestic violence. She's board certified in consumer and commercial law by the Texas Board of Legal Specialization, and she serves as the liaison to the American Bar Association's Commission on Domestic and Sexual Violence. She's also a co-author of the NCLC's Consumer Banking and Payments Law Treatise. And finally, we're joined by my colleague, Daniel, or I'll call him Dan Wilkinson. Dan is an associate and he's an advisor to banks, credit unions, non-banks, fintechs, auto finance companies. If it deals with consumer finance, Dan is involved. His practice includes new product launches, unsecured consumer lending, retail installment sales, compliance, licensing. And for purposes of the reason he's on today's webinar, he's been fortunate to have already counseled several creditors and other clients on how the new New York coerced debt law will apply to their businesses and what changes they need to make to their policies and procedures. So my thanks go out to all of our presenters today. Angela, we're going to begin with you. And I know you're going to provide as we look at the agenda slide that's up there now, we're now on what's really the second topic. You're going to provide an overview, and then we will turn to others, and that will be in a Q&A format with me asking the questions. But go ahead. The floor is yours, Angela.
All right. So I'm going to give you a little background on coerced debt. A lot of it is with my research with Adrian Adams and Angie Kennedy. So I need to credit them. They're professors at Michigan State University. I'm going to focus on giving you a little background. I'll tell you a little bit about our study and then a little bit about how we studied the remedies that were currently available and found them lacking as a setup to why we need the laws that have recently been passed. So background. Many people are surprised to learn that there's a relationship between debt and domestic violence. called coerced debt, right? It occurs when the abusive partner in a violent relationship obtains credit in the victim's name using fraud, duress, or manipulation. It's enabled by the tremendous growth of the consumer credit system, as well as its corresponding depersonalization. For example, mass deployment of consumer credit required depersonalization. The main way that your identity is verified, especially with credit card lending, is through knowledge of personal information, which intimate partners have. The system was set up not thinking about how it makes people vulnerable to coerced debt from intimate partners, right? Credit cards are the easiest to do, but with student loans, vehicle loans, and mortgages, we saw what will happen is the abuser will set everything up and then go and ambush the survivor and say, okay, you have to sign this now, and apply coercion. We have seen in our prior research a damaging array of credit transactions, such as fraudulently taking out credit cards in victims' names, forcing victims to incur debt for the abuser. For example, I interviewed a woman who discovered tens of thousands of dollars of credit card debt and car loans. On her credit report, her ex-husband had incurred them using his sister to impersonate her for the car loans. My research partner interviewed a woman whose husband used a combination of trickery and force that landed her with tens of thousands of dollars of student loan debt. And he managed to appropriate the money before it went to the school. So she owed it twice, once both to the lender and to the school. And I'll say more about how we define each type in a little bit. Debt can stay with the victim. Even if the survivor and abuser are married and divorced and the family court assigns the debt to the abusive partner, that does not change the victim's contract with the creditors. I'll say a lot more about family court below. Traditional contract offenses like duress do not work because the creditor is a third party who gave value and didn't know of the wrongdoing. Right? The creditor gave value by making the loan. The value was just appropriated by the wrong party. So one question I'm frequently asked is, how common is this? The best data we have on that is from our study of the National Domestic Violence Hotline, where we surveyed 1,823 callers for lifetime prevalence. We found that a little over half of them had coerced debt, 43% had it created through coercion, and 22% had it created through fraud. And coerced debt appears in every type of relationship, intimate relationship, gay, straight, multiple gender identities, married, dating, wealthy, impoverished. In our National Science Foundation study that I'm going to tell you about, we had participants in extreme financial distress, some making $0 per year, all the way up to a handful of participants whose ex-husbands were multi-millionaires, right? Debt tends to play out differently in different contexts. For lower income folks, it tended to be credit cards and subprime products. With higher income participants, real estate was a major factor, as well as business loans, i.e., putting the husband's business or just its debt in participants' names. Although that could happen with small businesses too, right? We had a participant whose credit card was funding the power washing business of her ex-husband and his brother. Zooming back out, we also hear from people working with elderly and foster youth that taking their credit info is part of the abuse they frequently experience as well. You may be wondering, how does somebody end up with this much debt without their knowledge or consent? And people are frequently asked, why don't they just leave when the alternative is financial ruin? Some background about domestic violence, also known as intimate partner violence, can help. there are two main types. Recent research has shown domestic violence. Situational violence, in which violence is mutual between the partners, and it's used as a less than ideal problem-solving strategy. On the other hand is coercive control, right, which originates with one partner. If abuse occurs more frequently, is more likely to result in injury. In heterosexual relationships, it tends to be gendered, perpetrated by men against women. And it also includes behaviors designed to limit the victim's free will, right? Such as controlling, monitoring, surveilling, belittling, humiliating, behaving erratically, gaslighting, doing all kinds of things, parts of coercive control to take away the victim's agency. Women are killed all the time by abusive partners, and leaving is the riskiest time in terms of being killed or having an escalation of violence. The fact that coerced debt takes place in coercive control, right? This is the type of abuse that we're talking about, is why we coined why we coined the term coerced debt. And to give you an illustration here, this is a quote from a participant in our study named Megan, who was a 27-year-old white college graduate who was married for 3 years. And she says, as we got close to the end of our marriage, he was like, you can't leave me because there's all this debt. And how are you going to pay off the debt? How are you going to handle your finances? How are you going to pay back your loans? She also had an autoimmune disease and did not have health insurance, which contributed. And so whenever the divorce conversation was happening, he was like, well, what are you going to do? I don't want to fuck you over, but how could you possibly handle all of that? It was just, I have you trapped, try to escape. So that's why I coined the term coerced debt, because it's debt that takes place in the context of coercive control, right? Why is coerced debt getting so much attention now is another question I was asked to address. I think there's two main reasons. First, the tremendous hard work of dozens of people, and then second, the issue itself. People like the ones talking later on this webinar have been meeting for years, especially from groups coordinated by the Center for Survivor Agency and Justice and by the NCLC. There have been dozens of talks and webinars. My research partner and I alone have presented to groups as diverse as Texas law enforcement, Midwest credit unions, Constitution Day at the South Carolina Financial Education Group, the National Conference of Bankruptcy Judges, and countless other bankruptcy CLE events. The CSAJ task force met quarterly for years and had several working groups working on all facets of coerced debt. In Texas alone, getting to the law we have now took place over 7 years across 4 legislative sessions and involved planning, strategizing, reaching out to members, testifying, negotiating. I personally spent a tremendous amount of time on it, and I was a minor player in the effort. And I know that's been true for every state law that's passed. None of them have been easy. The second reason is the issue itself is common and compelling. My experience of over 15 years that I've been presenting research on this topic is that many people hadn't heard of coerced debt, but once they do, it immediately makes sense. Among people working on domestic violence issues, there was immediate recognition. They had already seen it and seen a lot of it. They just didn't have a name for it. That's also true of people working with consumer debtors. When I've presented to consumer bankruptcy attorneys and bankruptcy judges, they too recognized it from their practices and their courtrooms. For people with no experience with it, the reaction is often, of course that happens. I don't know why I didn't think of it before, right? It just is something that intuitively makes sense. All right, so next I'm going to tell you very briefly about our study so that I can tell you about the legal remedies and how, spoiler alert, ineffective we found them. we had funding from the National Science Foundation, and one of the important goals was to study how victims seek and obtain help, legal help for coerced debt, and the effectiveness of that legal help. I will go into our methodology if people have questions, as well as our demographics, but you don't need to see them here. We had a fairly high income and highly educated sample. We can talk about that if you want. Huge variety in relationship length, and a lot of abuse, like 100% of other types of abuse and 83% of physical abuse. Battering, by the way, is abuse that measures the effects of living with coercive control. Everyone in the study had to experience coercive control. That was one of our study criteria, so it's not on here. This is a really interesting slide. It takes a minute to unpack, but it's worth it. It shows when the different types of abuse started in the relationships of our participants who were all getting divorced. We found them from divorce court records. You can see psychological abuse is the only one where there was a decent amount of participants experienced it while they were dating. For most of the other types of abuse, such as coercive control and physical abuse and economic abuse, people did not, almost 2/3 or more than 2/3 of people did not begin to experience it until their marriage. So it shows you how people can end up getting trapped and that the abuse does not start until you're fully committed. Here, I'll tell you how we defined the various transactions. In our study, for example, a fraudulent transaction was simply a transaction in which the participant's ex-husband opened or used her account without her knowledge. Coercive transactions, and here's an example of a fraudulent transaction, right? The participant here was Meredith, a 33, and we changed people's names, 33-year-old white college graduate who was married for 5 years. She said it was right before the study started. It was actually when I found out he was still using my social security number to apply for credit cards, and it put me in even more debt than I already knew about. When I had my credit report pulled for the study, I was appalled by some of the stuff that I saw on there because I had no idea what it was. Some of it was medical bills that he had agreed to pay on and just completely stopped paying on. Other stuff was credit cards that he'd taken out in my name. For coercion, we define it with a 2-part test based on how coercive control works. So there was a demand to open or use an account, and then we asked, what if you said no to opening this mortgage or credit card or student loan? Did your ex-husband think you might hurt you in some way or a loved one if you didn't do what he wanted? By hurt you, I mean physically, emotionally, financially, or any other way. We followed up with the question, tell us more about your answer. What do you think might have happened if you said no? And we counted something as coerced debt if somebody said yes to this question. To give you an idea of the kinds of consequences, a participant I interviewed, Sarah, who was a mixed race woman in her early 20s. She had 5 credit cards and 8 coerced debt. 5 of them were credit cards. And I'm just showing you the credit card debts that were incurred using coercion. For the first one, the consequence was silent treatment, and he would just go somewhere and take the car with him, so I couldn't use it to get to my job, right? So it was economic coercion. Second one, he wanted to blackmail me with photos. He wanted to hurt one of the pets. The third one, she said he would take the credit card and use it anyways, or he would take away something that I enjoyed. When I asked what she meant by that, she added her phone, her keys, access to Wi-Fi, or even take away the power. So it went far beyond things that she enjoyed. The fourth credit card, she was concerned about being kicked out of a moving car. And the fifth one, if she didn't let him use it, he probably would break the car even more than he already did and hurt the pets. His purchases on her credit cards ranged for food for him, to gas for him, to video games, to alcohol, to ammunition, just to give you an idea. The third type of coerced debt we studied, and this does not always apply during many of the laws, is manipulation. We said, looking back on it, if they said yes to a demand but no to coercion, do you think he manipulated you into opening the mortgage, student loan, etc.? For example, did he trick you, lie to you, or otherwise con you into doing it? We had very little manipulation in this study. Here's an example of somebody with manipulation. He told her to get a credit card to improve her credit score, but her credit score wasn't that bad. And he kept saying, we need it so you can buy a house, because she wanted to have a family and a dog, et cetera, et cetera. He said, you need to have a better credit score. Let's get this credit card. You can use it for gas and this trip that we want to go on, and then we'll pay it off immediately. It would be great. And it was obviously not great. She ended up with coerced debt on it. Here you can see in our study the tactics that were used. Coercion was by far the most common, followed by fraud. And this is by the account. By the participant, coercion and fraud come a lot closer, but still manipulation is much weaker. Just some background on the number of participants. It's the number who had coerced debt at divorce finalization that matter for all the legal remedies. I'll discuss very briefly. I know I'm getting to the end of my time. Here's the number of accounts. Median coerced debt participant, the total was 22,000. When you excluded mortgages and home equity loans, the median was about 15,000 per participant. We also coded participants' credit scores. And you can see there was a major difference between participants with coerced debt and participants without it, right? That their credit score took about a 30-point hit when you compared participants with it and without it. We also coded participants who had coerced debt. We coded their credit scores, including the coerced debt, and then deleting the coerced debt. And we found that a plurality of participants had a significant improvement in their credit scores when we took away the coerced debt. I'll tell you briefly about divorce as a legal remedy. We looked at, for legal remedies, whether they were available, right? Whether it's a remedy to address the situation, accessible, whether people could access it without being stymied by barriers, and acceptable, the extent to which the system comported with participants' values and beliefs. Here you see that in coerced debt, very few participants had the debt shifted to their ex-husband in their divorces. Again, that wouldn't change their contract with the creditor, but it's still important because at least they could indemnify, and 82% had no debt shifted. The reason was that very few people brought it up in the divorce, and they had good reasons. They were concerned about the advice of the attorney, risk of further abuse, pressure from their ex, child custody, child safety, etc. The most telling statistic is we asked about their satisfaction in bringing up or not bringing up coerced debt in the divorce, and people were significantly more satisfied when they did not attempt to shift their coerced debt than when they did. We also looked at debt service funds awarded in the divorce. Only one participant received money to pay coerced debt. The cash was to pay 3 student loans that still had balances. And we also totaled up all of participants' assets and compared it to their amount of coerced debt. When we did that, we found that participants had still, when we looked only at liquid assets, such as savings accounts and cash, participants had a median of negative 1,376 coerced debt left. When we also tallied it up for total assets, including equity in homes and cars, then people had $7,000 in median left after subtracting their coerced debts. But that included subtracting that they would have to sell or borrow against their homes or cars to pay coerced debt with that money. I am just about out of time, so I'll just tell you briefly the final punchline is that we looked at unauthorized use, Chapter 7 and Chapter 13 bankruptcy, unauthorized use requiring a police report, and the statute of limitations. And as you can see, we found that generally these were highly ineffective for participants. They were either not available, not accessible, or violated participants' values and beliefs. They'd be unwilling to use them. And that is it for me.
Well, Angela, thank you very much. That was an extremely helpful foundation. And it's surprising to me anyway that existing remedies are not helpful and they have not worked to eliminate this problem that you've described. I want to now turn to the broader conceptual, from this broader conceptual framework to the specifics of New York statute. And so we're going to go now to Divya and Naomi. You were both deeply involved in the coalition efforts that led to the enactment of the New York law. And you've also worked directly with affected consumers. So you can bring policy and practical experience to this discussion. So I have a number of questions I want to ask, and going to direct question to either you, Divya, or you, Naomi. But for any question that I raise, any of the participants on the panel should feel free to chime in. So let's start with a very basic question for you, Divya. Can you give us an overview of the New York coerced debt statute? What does it do and who does it protect?
Yeah, so coerced debt is a problem we've been working on for many years because we observed in practice exactly what Professor Litwin was talking about, which is that existing remedies could not get at the problem we were seeing our clients bring to us over and over again. And it's not something that just impacts domestic violence survivors, but a lot of other vulnerable populations that we serve. So we see a lot of older adults and people with disabilities who depend on, for example, caregivers for basic needs and end up being coerced into credit in their name that really just benefits the caregiver. So this law was supported by a really broad coalition of providers, legal services, domestic violence providers, as well as organizations that serve seniors and people with disabilities. And it creates a framework for survivors of all kinds of economic abuse to get relief from coerced debt. So under the new law, survivors can dispute coerced debt with creditors who then have obligations to investigate the claim and stop collecting it if it is coerced debt. Survivors can seek a court order making a finding of coerced debt, and it allows creditors a pathway to hold the right person responsible, right? The person who coerced the debt in the first place. Enforcement of the law is to be survivor-led. They can bring in action for damages and attorney's fees against a creditor who violates its obligations, and it allows the attorney general to enforce the law as well.
And I take it, Divya, they can recover if the monies that they've already paid, can they get restitution of funds through a lawsuit?
It wouldn't be restitution. The action would be for statutory damages and then actual damages that flow from the creditor's violation. So the remaining liability, and the statute is not retroactive. It actually takes effect in September because of the governor's chapter amendments, and it will apply to debts that are incurred after that effective date.
I see. Okay.
But I should say through the action, they could discharge that prior liability.
Right. Now, does the law, there's a definition of coercion, of course, in the law, and I'm wondering whether it basically is the same as what Angela generally described, or does it differ?
I think there's definitely a lot of similarity there. Obviously, it's a definition that has to fit within existing New York legal frameworks. And so that's what you'll see here as references to New York law, but it is an incredibly inclusive and strong definition in that it includes coercion as being defined as a duress, intimidation, threat, force, coercion, manipulation, or undue influence that may cause a debt to arise, a debt meaning debts concerning personal, family, or household purposes, and that coercion occurring within the context of intimate relationships or relationships between family or household members, relationships between victims of human trafficking and traffickers, relationships between children and their parents or caretakers, the elderly or individuals eligible for protective services. And each of those categories of relationships points to a particular definition that exists in New York law, but the inclusion of all of those populations of vulnerable people in which an abusive relationship is known to occur because there is a power dynamic that is exploited. It was important to the coalition that really backed this law and was inclusive of folks that advocate not just for domestic violence survivors, but for elderly people that are exploited, for children, for disabled folks, for immigrants that may be exploited in human trafficking situations. And so I think that very much tracks onto the definition that Professor Litwin uses academically in terms of like this occurring in this abusive relationships. And definitely you can see this through line of the work that Professor Litwin and her colleagues have done in academia, and we've all worked together in working groups with CSAJ. Definitely like this, a great partnership of advocacy and folks doing research on the ground to understand what coerced debt is.
What is, Divya, this question for you, what is the process that the statute establishes for a consumer to assert a coerced debt claim?
Yeah, so first, if a survivor indicates to a creditor in any way, whether on the phone, in writing, at a branch, that a debt was coerced, the creditor needs to send them an explanation of their dispute rights. And there's a safe harbor notice in the statute that makes that pretty straightforward. And then for the formal dispute, the survivor has to send what we call in the statute a notice of coerced debt, which is their own sworn statement about the debt and the circumstances of the coercion, and then some additional corroborating evidence. And there's a list of acceptable forms of evidence in the statute. And the idea is to have some sort of, under penalty of perjury, third-party support for the survivor's claim.
Mm-hmm. And so what kind of evidence is required? I'm going to ask you, Naomi, about this question. What kind of evidence does the victim need to get, and how accessible is the process for individuals that the law is intended to help? I mean, I'm curious, do they have to go to Campbell Legal Services? Is it something that an individual could do on their own? Tell us a little bit about that, if you would.
Yeah, it was very important that this law balance both having really rigorous evidence to support a claim that a debt was coerced and the need that obtaining that evidence would be accessible for survivors. And I'll talk more later about why survivors, the different sorts of challenges they'd have to access and to advocate for themselves. But here the law allows for a variety of evidence that is both rigorous and gives someone options. So in order to submit the notice that Divya described just now, you would just need to make a statement that a debt was coerced and identify that debt and provide adequate documentation, which is defined in the law to, again, give some options. So that could be a police report. It could be a law enforcement report. And the definition of a law enforcement report there, it's very important to say, includes an FTC report or could include an FTC report. It's much more accessible for a survivor to obtain an FTC report. Police report in this context would be difficult to obtain because coerced debt is not defined in the penal code in New York. And we already find it very, very difficult for survivors to get identity theft reports, where identity theft is defined as a crime in New York and obviously in other states, because of issues that survivors face in being believed by the police, being unwilling to go to the police in the first place, or an unwillingness of the police to open a case involving identity theft in the first place. So we wanted to make sure that when we're talking about law enforcement reports, that there's not a presumption that survivors are limited just to a police report there. And so it could include FTC, could include a lot of other law enforcement agencies. And then also the documentation could include a written verification from a qualified third party. And a qualified third party could include attorneys, it could include social workers, it could include members of the clergy, it could include doctors, basically any sort of first responder to the sorts of crises that survivors encounter and the people most likely to be informing a survivor of their rights and being able to connect them to the legal services they need, what have you. So just very important that it be as accessible as possible while still having that high standard of rigor.
And Divya, how does the law affect creditors and debt collectors in terms of their obligations once a claim of coerced debt is raised?
Yeah, so within 10 days of receiving the dispute, the creditor or debt collector has to pause the collection activities, report the trade line as disputed, and then they've got 30 days to conduct a review and investigation, make sure, all the components are there in the survivor's notice, reach a decision, within 5 business days, notify the survivor of that decision. And if it's coerced debt, the creditor has to stop those collection activities altogether, no more letters, calls, no lawsuit, and request deletion of the trade line. And that then opens up that pathway for the creditor to pursue the abuser who coerced the debt for the amount of the liability. If the creditor decides for whatever reason that it's not coerced debt, they have to explain in writing their good faith basis for that determination and enclose the documents they relied on. And then the survivor has the right to request reconsideration. And a survivor injured by the violation, as we talked about, has to give the creditor notice of the violation. They've got a 15-day cure period, and then the survivor's ability to file a private right of action is opened up to deal with that violation. Creditors do also have a bona fide error affirmative defense available to them in those actions, and it would be the creditor's burden to prove that they have, policies and procedures in place to prevent those errors.
Isn't it true that in most cases, I would think almost all cases, that a creditor or debt collector wouldn't have any reason to know that there was coercion involved from the person they're trying to collect the debt from? They're not going to have the kind of details, won't know anything until they're notified by the survivor and they receive documentation. Is that right?
That's right. Yeah, no one is expecting the creditors to be psychic about this, and that's why that right of action only kicks in once the survivor's gone through all those steps.
And I just want to note that in my, I practiced for 13 years and I managed a team of advocates that were helping survivors of economic abuse. And there were certainly cases where the creditor did know, specifically in auto loans. Like, it's difficult in credit card situations where everything's impersonal, online, and there might be flags there, whether it's synthetic identity theft or others. But in the case where it was an in-person transaction, auto loan, mortgage loan, there were signs. And I had specifically one client who, her abuser was physically intimidating her at the dealership in front of the person who was completing the loan, and also, pressuring her, pinching her arm. So there were signs that in those instances, the creditors would have been on notice, but certainly in other cases where it's all online, then Divya's answer would be accurate.
Yes, I completely agree, Carla. And we see those cases at auto dealerships and in-person types of transactions where the creditor is both a witness to the coercion and sometimes a participant. And that is a very different scenario. And I think creditors can avoid downstream liability by having policies and procedures in place that can prevent these accounts from being opened in the first place.
Right. Typically, the auto dealer doesn't hold on to the debt. The retail installment sale contract is signed by the dealer, but then very soon thereafter transferred to some finance company or bank that would not be knowledgeable about what had happened face to face at the dealership. So are there any specific, we're going to have in a little bit turn to Dan Wilkinson, who's had experience on the other side, but are there any compliance steps that financial institutions should be thinking about now in light of the New York statute?
Yeah, I can think. Yes, go ahead, Carla.
Yeah.
I was just going to say, back to your previous example that the assignee of that auto loan wouldn't know necessarily what is happening. I mean, we do have the FTC's holder in due course. There already are a lot of really bad practices that happen. There are indemnification agreements, that go on behind the scenes for this reason to address this. And so I think that that's one of those policies and procedures. If you are doing, auto loans or other types of transactions that you have in place with folks that are not directly your employees, but that are those that will then assign the contract to you. I think those are some of the things that I would consider, even if you're a debt collector or a collection agency, to have some of that language in place as well. And sorry, Divya, I didn't mean to step on your toes.
Yeah.
No.
Go ahead, Divya.
No, not at all. I think that that's one of the sort of compliance steps that I would say, that over time, as these disputes come in and financial institutions get a better understanding of coercion, these are red flags that you can see in the history of the transaction when the account is acquired, and looking for those red flags at the front end and, implementing procedures around accepting these accounts, collecting on them, stopping them at the front end, I think are important. In terms of fitting in the coerced debt investigation into some of the compliance processes that are already in place, as we're not expecting creditors to be the arbiters of whether someone was abused. That's the point of the documentation requires that are in the statute. If everything is there, there should be a finding of coerced debt, and it should be fairly straightforward. There are also critical pieces of the law that require confidentiality and protect survivors' safety. Many of the folks who are doing these disputes are dealing with daily continuing risks from their abuser, and it is critically important that the abuser not find out where they are. So the creditor's communications with the survivor shouldn't be containing personal information. The contact information needs to be kept confidential. Those may not be procedures that already exist, but they are really important to preserving survivor safety. I think creditors should also be training agents who are speaking with consumers about how to recognize when a survivor is raising a claim of coerced debt, because they may not always use that terminology. It might be as simple as somebody saying, my ex made me do it. And a lot of times what survivors hear back is, well, that's not a defense, but it is. And the survivor should then be told about their rights to dispute the debt as coerced. And, frontline customer service representatives should also understand and be trained on the kind of emotional circumstances that survivors are coming from. They're in really desperate situations. They have a history of trauma, and they deserve compassion and respect when they're bringing these disputes to creditors.
Thank you for tuning in to the first part of this webinar series. Be sure to join us for the second installment of this podcast on Thursday, June 18th, when Angela Litwin, Divya Subramaniam, Carla Sanchez-Adams, Naomi Young, and Dan Wilkinson will discuss the challenges survivors face in asserting claims, how the New York law compares to developments in other states, and the most significant implications of the law from the perspective of creditors, servicers, and debt collectors. To make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights about the consumer finance industry. And if you have any questions or suggestions for the show, please email us at podcast, that's singular, at ballardspar.com. Stay tuned each Thursday for a new episode of our show. Thank you for listening, and have a good day.